So, good morning, everyone. Thank you for joining us in this very exciting panel regarding experience and the application of Madrid Protocol. Well, since Brazil just recently enjoyed Madrid Protocol, we are all aware that it's just a matter of time, and we are going to have other Latin American countries join it as well. So this panel will be, we have very experts on the protocol over here who will be sharing their experiences, and we are lucky enough to have them with us. I would like to introduce our panelists today, starting with Anne Jaitovitz, who is the intellectual property attaché based in Lima, Peru. She advises U.S. government personnel and national IP offices and coordinates the U.S. PTO's activities in Bolivia, Chile, Colombia, Ecuador, and Peru. She has more than 20 years of experience representing songwriters, publishers, recording artists, and the U.S. government and digital technology companies, music technology, and copyrights. Also have Eric Castillo, who is a senior partner at UTOF Gomez, Vega, and UTOF in Mexico, with more than 30 years of experience. He is president of the Mexican Association for the Protection of Intellectual Property, AMPI, which is the Mexican group of AIPPI. He is a member of other international associations such as INTA, AIPPI, and ECTA. Eric was educated in Mexico and also holds a degree from Franklin Pierce Law Center and continues its education by attending seminars throughout the world. Luz, by my side, is a partner and heads Denton and Cardenas Intellectual Property and Technology and Privacy and Cybersecurity Practice Group. She is regularly ranked as a top-tier lawyer in the field by major legal directories. She has more than 30 years of experience managing complex IP portfolios for multinational and local companies. And finally, over there, we have Tove Groundland. Tove was in-house for 20 years at the Danish-Swedish dairy company Arla Foods. She was director trademarks at Zacco and now runs her own company where she offers business development services to IP law firms. She was the chairman of Marx for 5 years. As an NGO, she has worked on promoting and improving the Madrid system and is an expert on the pros and cons of using the system. She has attended the working group of the legal development of Madrid system at WIPO since 2005. She is a special advisor to the executive director of the EU IPO and thus remain actively involved in the development of the IP systems. So as you see, we have a group of experts here covering most regions of the world who will be sharing with us their experiences and what I think is the most important thing, advising us on practical tips since they're used to something that is pretty new to all of us, um, including myself, of course. I'm a Brazilian, and I should introduce myself as well. I am Joana Siqueira, partner of the law firm Montalvo de Pimenta in Brazil. And as we are all aware here, Brazil just recently joined the protocol, and we are getting used to that. And I truly believe that Brazilians will take a lot of advantage of that panel. So I'm very happy and honored to be part of it. And again, they all have a lot of experience, but a lot of us don't. And just before getting into the practical tips that I'm sure it's going to be very useful to all of us, we are taking a step back and starting the panel with some basic information on Madrid Protocol, because we wanted to make sure that all of us are on the same page here. So in the end of the panel, you just feel free to ask anything you want, and take in mind that there is no silly questions in a nice way, but just be comfortable because it's something pretty new to the majority of us here. So, Luz, so tell us, what is the Madrid Protocol?
Thank you, Johanna. Y gracias a todos. Como la mayoría de la audiencia está en español, voy a hablarles en español. Primero que todo, agradecer a Asipi por poner este panel hoy en este día en un tema que es nuevo para Brasil, pero yo diría que también es nuevo para la región. Y las experiencias que hemos tenido también pues, son útiles a pesar de que seguimos aprendiendo sobre este nuevo proceso de registro de marcas. Y gracias a mis compañeros también porque han trabajado en este tiempo fuerte junto con Johanna para poner este panel a funcionar. Bueno, ¿qué es el protocolo? A pesar de que yo sé que muchos de ustedes ya saben qué es el Protocolo de Madrid es un tratado que hace parte de un sistema que es el Sistema de Madrid, junto con otro tratado que se llama el Arreglo de Madrid. La mayoría, el protocolo se puso a disposición porque provee, digamos, a muchos países mayor flexibilidad en el manejo de las marcas. Es un sistema alternativo a los sistemas que ya existen. Los sistemas nacionales y locales siguen en curso, los sistemas de registro de marcas como la Comunidad Andina, como la OAPI, como el registro de la marca comunitaria europea, son sistemas que también se mantienen y simplemente este Protocolo de Madrid se presenta como una nueva alternativa para el registro de marcas. Provee ventajas especiales en la posibilidad de presentar una solicitud única en varios países a la vez y además esto da la posibilidad de administrar este portafolio de marcas de una manera unificada y eficiente. Y como les dije, esto se presenta como una alternativa y con cada cliente lo que debemos es revisar cuál es la conveniencia de usar el sistema o no. Y en muchas oportunidades va a ser más conveniente usarlos, en otras probablemente será mejor utilizar los sistemas locales que ya se venían utilizando. Eso dependerá de cada caso, de cada marca. Hay compañías que pudieran decidir iniciar su proceso, utilizar el Protocolo de Madrid cuando sencillamente esperan sencillamente a que han posicionado su marca en el mercado y esperan hasta tener esa seguridad para iniciar, digamos, el proceso en el Protocolo de Madrid. Otros quieren iniciar el proceso muy temprano, apenas solicitan la marca en su país de origen, beneficiándose probablemente de las prioridades que ya cuentan en ese momento. Y otros sencillamente esperan a tener un registro concedido para poder iniciar el proceso. No sé si alguno tiene alguna otra cosa que decir.
Thank you so much. And Tove, can you give us some advice on how to file an international application?
Yes. Okay, I think I'm going to have to not listen to myself. All right. How to file an international application. You have to have a basic mark in your own country. So you can't just file in Geneva. You have to first file typically in your home country to use that as a basis for your international application. You can do it on the basis of an application, or you can wait until you have your registration. Then when you want to file your international trademark, you file it in your home office again, the same office as the basic mark. The office will then examine the international application to look at the triple identity, that it's the same owner, it's the same trademark, it's the same list of goods. And then they will pass it on to WIPO. WIPO will then examine from their perspective, specifically on the list of goods. And after that, they will send the application on to each designated office.
Thank you. And Eric, how do you pay the fees?
Well, good morning to everybody. And basically, what you do is you have two steps. Most of the offices would require that you pay a fee before the local office in order that they forward the petition to have the international registration, and then you would pay the fees directly in WIPO. There are some methods to do it. How you pay the fees to WIPO, it could be you open an account. So that's one of the ways to do it. You can do it through a bank transfer or with a credit card. And there are some few offices that you do the payment directly to the local trademark office. For example, in Mexico, nowadays you do the payment directly to WIPO, but there are some talks that you're going to do the payment directly to the Mexican Patent and Trademark Office. So then the number of countries you designate, those are the fees that you're going to be able to pay directly to WIPO. Instead of doing two payments, you only do one. But that's maybe a couple of months from now.
Thank you. And what can you expect from the examination?
Well, first, thank you. I have to take this off.
Yeah, we're having a hard time with that.
Thank you very much to Asipi, to the audience, and to my fellow panelists. Examination of a request for extension of protection, that's an incoming application to where your office has been designated, is similar to an examination of a national application. The country applies its own laws in determining whether to grant the trademark protection. It's not an Madrid Protocol set of laws. It's the country's own trademark laws that are applied.
Okay, I think it would be nice also to have any comments from Eric and Luz on this matter. Would you like to share something?
Sure. Luz, you want to go first?
Yes, I agree. Estoy de acuerdo con Anne sobre, digamos, la necesidad de que la oficina local, la oficina nacional que recibe la extensión territorial hace su propio examen, pero es importante también aclarar que cuando se presenta la solicitud en un país base, hay un momento donde la oficina internacional va a realizar también un examen de forma, va a revisar si el formulario se presentó bien, si los datos coinciden, si el distingue de los productos coincide. Entonces hay, digamos que esa primera fase de examen de forma. Luego, cuando ya la marca entra a la oficina, a la extensión territorial, ya viene la oficina local a aplicar sus propias normas de examen ya de fondo, donde puede hacer observaciones o se llaman denegaciones provisionales de oficio, cuando ella revisa su propia base de datos y puede definir si hay algo que se parece o no, y también si hay oposiciones de terceros, ella misma hace su propio proceso y aplica sus normas legales en términos de notificaciones, términos a los terceros para responder tanto las objeciones ex oficio como las oposiciones.
Thank you.
For example, in Mexico, something important that I want to recall to the audience is the statistics that you see from WIPO is that almost 50% of all designations made to Mexico receive nowadays an official letter from the Mexican trademark office. And basically, it's for two reasons that I see. That it's aside of a novelty examination, but in formalities, it's two reasons that I see is usually the applicants in the home countries use phrases as parts and fittings or parts thereof, and it's something that is not accepted in Mexico. You need to be really specific of which parts you want to protect. So if you have something like Class 12 automobiles and parts thereof, you need to be specific on which parts you wish to protect. So if you file an application, let's say an Italian company files an application, and it has this description of automobiles and parts thereof, they usually do the translation into Spanish, and when the trademark office examines that, they will issue an official letter. And second of all, is when they file in a different language than Spanish, usually is English or French, the translator machine or the translator software that is used by WIPO does not make an accurate translation of the goods or the services. So usually those applications will also receive an official letter. So it's something that you need to take care of that. And when it comes to you, well, you will need a local representative to answer that official letter.
Okay, thank you. Actually, we've been listening a lot of that, and just Brazil just joined protocol, and we are getting ready to deal with this kind of situations. Luz, can you expand an international registration with more countries?
Sí, se puede designar países adicionales, no solamente al momento de iniciar una solicitud de registro internacional, sino posteriormente se pueden hacer extensiones adicionales. Estas extensiones pueden ser inclusive presentadas directamente por el solicitante de la marca. Creo que no tengo nada más que decir.
Thank you. Eric, how do you assign an international registration, and does it apply to all countries covered?
Concerning assignments, first you file the assignment. It can be by or three different ways. The first is that the owner directly goes to WIPO and fills out the form. It's a form, I don't know, MM something, I don't know, but you just fill it out and you send it directly to WIPO. The other is that either the assignee or the assigner, they use their local office. It's important that the office of the assignee is also a member. So let's say it's a Mexican company that is assigning to a company nowadays in Peru. It would not be possible because Peru is not yet part of the Madrid Protocol. So both parties need to be, well, at least the assignee needs to be part of the Madrid Protocol, so that you go to your local office and they forward the corresponding form directly to WIPO. And one important thing is that there can be a partial assignment. You can assign part of the goods or part of the services, or you can also assign part of the contracting countries. You can do all of them. Let's say you have designation for 60 countries. You can do the 60 countries, or you can select only a few of them. And an important thing is WIPO does not require to receive any kind of evidence. You do not need to submit the assignment document. You just fill out the form and say who is the assigner, who is the assignee, and that's it.
Okay.
So it's a fairly easy procedure.
Yeah, we noticed that. But in Tove, what is replacement?
Yeah. I got so entangled before on the technical stuff that I forgot to say all the nice things, like thank you to Asipi for inviting me to be a speaker. This is my first time at Asipi, so I'm very happy about that.
Welcome.
And it's also my first time in Peru, but that's a different story. So replacement. Replacement is not used very much. Those of you who have worked with the Alicante office, who know about the EU trademark, will know that there's something called seniority. And replacement is very similar to that. So it means that you can take, if you have a portfolio of trademarks in many countries, you can file an international application and designate those countries. And then you can say, I want to replace my national by my designation. Then WIPO will record the original date, so maybe going back 50 years, into the international system. And the local office, Norway or wherever, they will make a note that this right is now replaced by international registration, such and such. It sounds very complicated. I'm afraid it probably is. Right now, we are trying to improve and make it more easy. The whole point is to bring a portfolio of registration into one so that you can benefit from the beauties of Madrid, which is the assignment, for instance, no documents, just one filing. And I mean, when I was in-house, we did that. We watched who's joining. Israel joined, so what do we have in Israel? What do we have in international? And then we would transfer them in so that we could save the money later on renewals and so on. This was a farmer's country, and farmers don't like to spend too much money. So it's something I recommend looking at. There is one particular thing with Brazil, though.
Okay, go ahead.
And that is 6 countries now. 6 countries now tick the box where they said you cannot do replacement on a registration that is younger than the date of us joining. So in
That's
that case,
correct.
you won't be able to do it with an older registration. And Brazil is one of them.
Yes,
But
yes, definitely.
I mean, this is one of the sort of refined tools of the new option you have.
Okay.
I wouldn't worry too much about it, but it's really interesting from the owner's perspective to try and reduce the size of your portfolio and bring it into one.
Thank you, Tove. Luz, so tell us, how do you renew, and does it cover all the countries?
Johanna, las renovaciones se
The microphone.
micrófono, perdón. La tecnología nos avasalla aquí. Bueno, las renovaciones es uno de esos momentos donde el sistema, el protocolo de Madrid es bien útil porque se hace una sola renovación única para todo el registro internacional que de alguna manera permea todos los registros locales también, para el registro internacional. Existe también allí el periodo de gracia que hay en muchas de las legislaciones, inclusive en el Convenio de París, tenemos la fecha de vencimiento y hay un periodo de gracia de 6 meses para renovar, obviamente pagando las tasas adicionales que haya que pagar. La Oficina Internacional realiza inclusive un recordatorio después del vencimiento, antes del vencimiento del periodo de gracia, lo que es bastante útil. Es importante también aquí indicar que para aquellos países adicionales que se han sumado y que tienen una fecha de vencimiento, todas van a conservar la misma fecha de vencimiento, de manera que al momento de la renovación incluye todas las designaciones que han venido posteriores y van a conservar todos la misma fecha de renovación. Importante también creo que es muy importante para aquellos países que requieren cumplir con requisitos adicionales al momento de la renovación, como por ejemplo Estados Unidos o Nueva Zelanda, que necesitan presentar declaraciones de uso. Colombia no es el caso. Es importante que se tengan en cuenta, digamos, esas situaciones especiales al momento de la renovación.
Okay, thank you. Eric, would you like to share with us what are the advantages
Sure.
of? Go ahead.
Just before, as Luz was saying, it's important to also consider that in Mexico, our law was amended last year. And with renewals, you also need to file a declaration of use. Because she mentioned about New Zealand, no, and the US case, but for the audience here, that I believe some of the persons here might have protection of brands in Mexico. It's a new provision, and upon renewal, if you file the renewal of the international registration, you will get the renewal of the same through WIPO, but then 3 months after that, you have this term to file a declaration of use. And you need to do it with a Mexican legal representative. So it's important to acknowledge that thing. Everything is included on WIPO's website, but it's something important to acknowledge. Now, considering the advantages, I believe that it is a good option for a lot of companies because you file one application. It's one. You only pay fees for the designated countries. You only pay legal fees to the local law firm that is helping you with the corresponding process to get the international registration. Spanish is one of the accepted languages, which is good. So, for example, for Mexican companies, you can file in Spanish. Not yet Portuguese, but I don't know if it was part of the negotiations. And one big advantage is that the more countries that join Madrid, the better or the bigger the menu you will have. For Mexican companies nowadays that usually go to Central and South America, well, it's only a few countries that are part, but as more countries join, and it's in no way I am promoting that to the governments that they join, but if you ask me, I think it's going to be a best option for most of these owners to have another option to try to register their marks, either regularly or through international. So those, I think, are the biggest advantages, that it's only one mark, and once you get the registration, as Tove was saying, the maintenance of the same is much, much easier. You only have one registration, maybe covering 60 countries or 60 jurisdictions, and the assignment, the renewal, a change of name, whatever the procedure you need to do, it's going to be even a change of address, which is really complicated when you go country by country, and it takes a lot of money. Well, a change of address is a fairly easy procedure to take.
Okay, thank you. Luz, comments on that? Tove?
Totalmente de acuerdo con lo indicado por Eric, y creo que una vez que más países de la región se sumen a este tratado, muy probablemente se va a convertir en una herramienta muy útil, especialmente para las compañías de nuestra región, cuyo comercio natural evidentemente está en la región. Entonces ello seguramente se va a constituir en una herramienta adicional, en una alternativa adicional de protección, con las ventajas que Erika acaba de puntualizar, y es poder administrar estos registros de una forma menos costosa y más eficiente.
Tove, something to add?
I'm just listening to the translation first.
Oh, I'm sorry about that.
So there's a little time gap there.
I'm sorry.
Well, just very quickly to add from the in-house perspective, the filing cost, the actual filing cost compared to filing national, and I mean, it depends on the amount of countries, of course, but it's about 50% reduction. However, one should not forget, like you've already said, now getting a little bit into the tips and what you need to be careful with. The national examination, the national treatment of the designation will be exactly the same as before. So, as you said, at renewal, you still need to file, just like before. I'm old enough to remember before in my country, that was 96. You have to file the affidavit in the US. You have to comply with the rules in Japan about the list of goods. So, in the end, the savings you made at the filing may be used on getting through the objections. So people tell me, oh, I don't like Madrid because it's slow, it's difficult. It's because you have the wrong expectations. Expect problems with the filings, just like if you filed it national. So the big advantage, as you said, is once you get past that, once you get approval in the countries, that's when it really kicks in. So the renewals, you can do subsequent designations at countries. You can distract countries when you renew by just not paying the fee. If you don't need Egypt anymore, for instance, or whatever. Assignment, change of names, that's where the real benefit comes. During examination, when it's still an application, you're going to get the same, I don't want to use unpleasant words, but the same difficulties as if you file national. I would also, one additional important benefit is no documents, no legalization, no translations. All of that bureaucracy is gone, which is very nice. And then I would recommend going on the WIPO website, looking at the online tools. I mean, they really keep developing the ways which helps some of the national offices as well to improve what they do. I mean, we shouldn't forget Brazil. The examination time in Brazil was how long? 2 years?
More.
More?
Yes.
Now it's come down to
Yes.
10 months.
Yeah.
And I think, is it wrong to say this is thanks to the Madrid?
No, I think it's a way that it makes the country improve
Yeah.
the trademark office to
Yeah.
adjust to Madrid. So
So that's
I
one of
agree with you
the
that
sort of
it's an
advantages.
advantage.
It's
Yes,
kind
of
one
course.
of the good things. Yeah,
That's
that-
right.
That
That's
the
right.
system brings. So if a
'Cause-
country wants to join, they need to step up on user benefits. I mean, how they deal with you, how fast they work. I mean, with great quality still, of course. We look for everything at the same time.
Yes.
Thank you.
Thank you. So, and what do you need to be careful with? Luz? Do you want to go with that?
Sí, esta es una pregunta bien importante y yo empezaría por decir que una de las cosas sobre las cuales se debe tener muchísimo cuidado es durante el periodo de dependencia. Es decir, durante los primeros 5 años, donde el registro internacional va a depender de lo que le suceda al registro base del país de origen. Ese registro base se constituye en la piedra fundamental para que se mantenga vivo ese registro internacional y, por supuesto, los países que han sido designados. Si ese registro base es abandonado, es cancelado, sufre una negación, pues todos los registros internacionales y registros de países designados se van a caer como un castillo de naipes. Inclusive después de los 5 años, pasados los 5 años de dependencia, si la solicitud nacional todavía no ha llegado a registro y está, por ejemplo, en un proceso de oposición o en un proceso de cancelación, también cualquier decisión que se suceda después de los 5 años, pues va a tener un impacto importante sobre ese registro internacional. Por eso es muy importante monitorear y vigilar de manera muy juiciosa y muy detallada y ojalá con un abogado local que esté vigilando ese proceso, esa solicitud o registro base para que pueda proteger, digamos, durante el periodo de dependencia ese registro internacional. Otro tema que creo yo que es importante tener mucho cuidado es en la etapa de las denegaciones provisionales que la oficina internacional le informa a las oficinas locales, porque no todas las veces los términos son los mismos. En cada oficina los términos son diferentes, las notificaciones se suceden de forma diferente. Entonces, creo yo que esas dos situaciones, a menos que mis colegas tengan otras, son tal vez en las que más cuidado habría que tener.
Tove, do you want to add something?
Yes, thank you. I have some very specific tips. Again, it's all based on the fact, don't forget that the designation needs to be approved according to local practice. So when you designate the US, I recommend that you add an extra sheet of paper and you limit the list of goods to the actual goods of interest, just like you would have to have done if you filed a national in the US. You could do that at the filing on the international, and I recommend to do it up front. The US office will find something else to object to. This is, so, I mean, if you get an irregularity notice, this is a new word you will need to pronounce. I struggled with that a couple of years, irregularity notice. If you get one of those for the US, don't despair. It happens to 99% of us. So I don't know, it's just, yeah. Then it's far away, but some of the African countries have not implemented the Madrid Protocol into their laws, which obviously creates uncertainty. You're not sure if the judge will recognize your designation because it doesn't exist in the law. So Lesotho, Liberia, Sierra Leone, Sudan, Swaziland, and Namibia. I know it's far away, but if ever, you want to look those up and be careful. Another tip, when you get the international certificate from WIPO, your clients, when you send it to your clients, you must communicate very carefully because they think, I got it, I have a certificate. No, because it hasn't been examined yet in the countries. So I don't like that they call it a registration certificate. To me, it's like a filing receipt. So be careful when you communicate it to the client. This only means that WIPO's happy. Now we have to go through the process in each country, and then we'll see what happens. Otherwise, they will be very disappointed when you get the refusal from the USPTO or Japan or Korea or Russia, somewhere else. So careful there. Also, I remember receiving these wonderful irregularity notices from WIPO, and you read them, and you read them, and you read them again, and you think, I'm a grown-up woman, I'm experienced, but I don't understand what they're telling me. So don't despair. I mean, WIPO letters can be difficult to decipher. I don't know why. I think it's because they do copy-paste. Deadlines can be difficult to calculate. You need to calculate the deadline. I hate that. Sorry. And I've told them, we don't want to calculate. We want you to tell us when the deadline is. How difficult can it be? I'm trying. But they will say the deadline is 2 months from the receipt at WIPO or at the office or with you, which again creates these unnecessary uncertainties. I love Madrid, but there are things that could be improved. It's difficult to know what is the exact date for the use requirement. From when does it run? That's also another complication. It's being discussed also, so hopefully we'll find a solution. As an applicant, you may select English as your language, and then you're surprised when the Russian office issues a refusal in French. The language that you select applies between you and WIPO. The offices will do whatever, just so you know. Now, I remember somebody said to me, so you think trademark attorneys have no value? Of course we have value. I'm a trademark attorney. Of course we have value. Local advice remains essential because of all of these difficulties. We need you guys. It's really important. Another trap is the second part fee. I'm sorry that Brazil chose to have a second part fee because it creates a lot of problems. The second part fee is the registration fee. These countries, so you have an application fee and then a registration fee. The countries that have this, they think they do us a favor, but actually it creates problems. Japan is one. Japan, Cuba, Ghana, and Brazil. It has happened a number of times that I hear from people, they never receive the alert to pay the Japanese second fee, and then bam, you lost it. Because you never heard. So that's a frustration. Be careful with that. Pay attention to that. You may get special registration certificates, even though it's a designation. I think you get it from the USPTO, right? It's very confusing. You get that in the post. I remember getting it thinking, why did we file national? We didn't, but they think they need to still do this for us, which is okay. In China, I would actually recommend that you ask for a local confirmation of your designation, so you have it on file. Because if you need to chase a counterfeiter in China, the Chinese court will they don't want to have this strange-looking Latin document from Geneva somewhere. They want to have something in Chinese. And if you have an injunction and you go to the Chinese office and say, I want a certificate showing my right, they may take 6 months to issue it. So in this case, you want to actually ask for it, just have it on the file in case something happens. What else? I mean, Madrid is great, but you need to be on your toes on certain things. I mean, I think the biggest problem is the fact, well, it's not really a problem, but Madrid reveals the different practices on list of goods. In the old days, you would file in different countries, and the examination would come in at different times. The office in Malaysia would object to the list of goods. You would adapt it, blah, blah, blah. In an international file, you get it in the same sort of time space. And then you start wondering, why is Japan not happy? Why do they want it like this and the USPTO want it like that? That can be really frustrating, but that's what it is. I mean, we're trying to harmonize it, but it's quite hard. So I just want you to know what to expect. I mean, the system is good, but there are things to look out for.
And
Solo
go ahead.
para complementar lo que dice Tove en relación con el tema de las listas y las descripciones de los productos y servicios, Siempre la oficina internacional va a tener la última palabra en el proceso, digamos, de proponer, y la oficina local también proponer. Al final del día, siempre la oficina internacional va a tener la última palabra.
And if you permit me, concerning what Tove was saying, concerning the deadlines, at least in my experience, because you receive the official letter from WIPO and you don't know which is from which date you need to count the deadline.
Exactly.
For example, in Mexico, it's 2 months plus an extension of term of an additional 2 months. What we do is we count the date that expires the first. So it's easier. At
To be on
least
the
you
safe
know that
side.
exactly, because to be on the safe side, you just see on the letterhead, you see these different dates. Well, choose the one that expires the first, just to be sure that it doesn't get a wrongful interpretation and eventually someone challenges your registration. So that would be my advice
Yeah.
for these kind of things.
Well, I mean, I was in-house, so my advice because I would have a team of assistants and they would be like, oh, when is the deadline? And I would say, don't think about it. Put it in the fax. Sorry, this was the older days. And to our friend in Brazil, in Mexico, in wherever, and ask them, what's the deadline? What's the problem? Tell us what to do. I think that's just from an in-house perspective, that was clearly the safest thing to do. And even, I mean, if I was an attorney, and I would rely on my local. I mean, you have to have that. Luz, when it comes to the list of goods, the national offices will decide about the designation. They will decide. I mean, the international registration will have a list of goods, but the designation will be according to local practice. They will have the final word on that.
Yes, but when you go from Yes, pero cuando vas del país de origen hacia afuera y hay algún término,
Yeah.
en ese caso sí
yeah.
es la
Okay.
oficina internacional la que toma la última decisión. Es a eso que me refiero.
Yeah, okay, thank you. Yeah, agreed.
Okay, so let's say with all these disadvantages, would you still use Madrid?
Yes. Yes, this is a short answer. Because of the, as I said before, going through the application procedure, all the examination, it can be a pain in the neck. Specifically because Madrid reveals all these different practices and you think, why is it like this? But once you get past that, that's when it becomes, it's like, we're here, one renewal, one assignment, that's it. I mean, that's just the beauty of it. So,
Luz, do you have something?
Yo diría que sí, hay que escoger el Protocolo de Madrid siempre y cuando la marca o el portafolio de marcas que estratégicamente escoja una compañía tenga la potencialidad de poder surtir el proceso con los menores inconvenientes posibles, aunque siempre va a haber, porque no todas las marcas, digamos, tienen esa potencialidad. Entonces yo creo que hay que revisarlo con el cliente caso por caso y si se puede convertir en una herramienta eficiente, pues hay que usarlo.
Thank you.
Lo mejor para el cliente siempre.
De acuerdo. So, Anne, when and why join Madrid Protocol?
The Madrid Protocol is a one-stop solution for trademark holders to obtain and maintain trademark protection in multiple markets. It really helps the trademark holder manage their brands efficiently. As you've heard already, you can file a single application in one language and pay one set of fees to apply in multiple territories. The Madrid Protocol helps trademark holders manage their brand through the centralized system and expand into the new markets. Do you guys keep hearing that squeaking sound?
I keep. Yes, I am.
Okay. I don't know what it is. So, according to what WIPO says, the Madrid Protocol now enables registering and managing your trademarks in countries that represent 80% of world trade. So it's cost effective and it saves time and money in filing one application rather than a bundle of applications. I know some of you local trademark attorneys might be concerned, but for local attorneys, the foreign applicants will require your services as they designate your country. They're going to need your assistance, as you've heard, in responding to office actions, and there will be some of those,
Yeah.
and navigating the national trademark structure that they're not so familiar with, because the national law is what will be applied in the examination. But finally, it's not only good for stakeholders, but it also benefits the country. The Madrid Protocol facilitates the protection of trademarks for foreign entities, which enables them to protect their businesses in your territory. Knowing that, it encourages them to set up businesses in your country and invest, and that is going to create economic growth for the economy of the country.
Eric?
Well, we cannot deny that it is a great option. Just the statistics for 2018 are really overwhelming of how many registrations exist. If you see the statistics in WIPO, you will see that it is more than 60,000 applications that were filed in 2018. With the designations, it is almost 400,000 of applications filed just in 2018. And international active registrations, it is almost 6 million that
Wow.
exist nowadays. So it is used. It is used widely by multinational companies. And I would say that, at least in my opinion, when there were talks in Mexico about joining or not, we had a lot of fear. Us practitioners, the
I think
local
it happens
firms.
to everyone, right?
Exactly. No, we had a lot of fear that we were going to be losing a lot of the filings, a lot of the work. And eventually, we know that the companies are using it, but still, it comes back. It comes back, the work, because as we were discussing earlier, the local trademark office will usually conduct an in-depth examination, and with the examination, official letters will be issued, and you will require the use of a local attorney in order to respond the same. For example, I know that in Brazil you need to appoint, since the beginning, a local representative. In Mexico, we have the...
In
No?
Brazil?
Yeah, no? There was that?
No?
Oh,
No.
I
no,
thought
no.
it was...
Unfortunately, no.
No,
No.
that's what they wanted.
That's
Okay.
what we wanted
I thought
to,
it
but
was, yeah.
unfortunately,
No.
no.
But,
After,
okay, perfect.
no, it's just, okay, though, just to make it clear, what they're saying is that it's mandatory by our law after registration.
Okay, after registration.
If the trademark turns to be in a court issue, to have the citation, is that right? I'm sorry if I'm missing the word here, but in this case, you must have an attorney or someone empowered to
Okay.
receive citations, okay?
But still, there's going to be other requirements and other legal procedures that eventually the work will...
No, if everything flows
No, of
pretty
course.
well,
You
I mean,
won't.
we won't need, but if something comes up, definitely
For sure. And
they're
for
gonna
opposition
need-
and other
yes,
kind,
they're
like,
gonna need
for example, in
an
Mexico,
attorney.
well, our law was reformed last year. But before that, if a mark was designated and it went through to registration, we never knew about it. And it was just one of the existing registrations on our registry.
Yeah.
And that was it, no? But
Yes.
still there's opportunity. For example, some statistics for Mexico. Just last year, there were like 135, 140,000 applications that were filed before the Mexican Trademark Office, out of which a little bit more than 10,000 received official letters. No, sorry. Out of the 130,000, 10,000 were international.
Okay.
International. So it's less than 10% that of the corresponding of the total of applications filed before the Mexican Trademark Office. So even though we are talking about 600,000 worldwide, etc., just for our universe, it's less than 10% of the applications that are using Madrid to go to Mexico. So maybe that's going to be something similar in other Latin American countries. I don't know Brazil, but there should be something maybe around that average. No?
Okay, yes, that's what we expect. Actually, when we're guessing about how things are going to happen in Brazil, we really would like to discuss with our Colombian and Mexican colleagues, because in the end of the day, we believe that it's the markets that are much more like similar to our.
Much more alike.
Yes, that's right. Okay, so let's get now to what we really want to hear from you guys. Clue tips on how to get prepared as a country and as a law firm. Who would you like to start? Because I know you all have something to say about it.
If you want, I can start.
Go ahead.
Well, the first thing is you need to get prepared as a law firm for the upcoming work that is going to show up. No, we know that it's a new system, a new way of dealing with things, but you need to get prepared. Like, for example, this, no, with seminars, with different conferences that you attend and you listen from the experience from other colleagues. In our case, Colombia had joined before us, so we listened a lot from them. We listened a lot from the US also because they had joined before, so we learned from their experience, and we also helped the Mexican trademark office in their input of things. No, we didn't know what to expect. Now we know, with this almost 6 years of dealing with that, we know the average of applications we receive, the average of official letters. But the thing is just, well, be prepared to record everything on your system, be aware of the deadlines. If you have local companies that want to use Madrid, well, you need to also have experience in all these kind of procedures, going to the Mexican trademark office, doing or choosing for the international registration, designating the countries, doing the payment. Then when you go to the local offices, when the trademark applications are under examination, you're going to be learning about all of these things, receiving the notifications by email. So it's something that you're going to be learning, but it's something that it's the learning curve, it's fast because you are already there and the clients are expecting you to know. But the thing is that most of the Mexican colleagues, when I was dealing with this, were on the same level. Everybody's uncertain. And it was a talk, really, when we were cafe talks and everything. We were like, okay, do you know about this? How do you transform the trademark? How do you do this? And it was something we just help each other.
Yes,
no, it's a good thing.
It's going on in Brazil right now.
For sure.
Yes.
And it's the only way to really be united and help each other, because something new is going to come to you that I didn't know about it. And it's good that you know. And if you ask me, then we go to the local trademark office and we ask. And even they are not aware of that. But they will ask WIPO. And WIPO is really open to answer questions, to see how things are going to be occurring. So that would be one of my first tips to do that. No?
Bueno, aparte de lo que ya ha dicho Eric, con lo cual estoy completamente de acuerdo, yo diría que desde el punto de vista de país, por supuesto las oficinas de marcas, contar con equipos sobre todo estables, porque el manejo del sistema del protocolo pues presenta ciertas complejidades, y tener examinadores en la oficina de marcas que tengan el conocimiento del proceso pues es importante. Entonces yo diría que ese es uno de las cosas importantes desde el punto de vista de país y fundamentalmente de la oficina de marcas. Y desde el punto de vista de la firma, por supuesto, tener claro el proceso, pero inclusive poder estar sentado uno con el cliente y poderle uno dar la opinión de cuál es la mejor estrategia para usar el protocolo, cómo usarlo y qué marcas, digamos, tienen la posibilidad de tener éxito utilizando el proceso. Y creo que es importante también saber que la WIPO tiene un help desk al que uno puede recurrir ante cualquier duda. Eso me parece que es una herramienta importante para utilizar en la medida que estamos en esta curva de aprendizaje que ha mencionado Eric, y ayuda muchísimo.
Tove?
Yep. One of the things that I've heard is, I mean, I'm now speaking about the office, how to get ready. The office, of course, needs to examine the designation, needs to issue its first official action, if there's anything to issue, before the 18 months. What's very important for me is that it doesn't happen any faster than the national application. So I mean, really want to see constantly equal treatment between national applications and designations. To me, that's a given. To rule that out. I don't want preferential treatment. And that means that Madrid is good for everyone, not just because it brings the examination time down to under 18 months, even faster, as we've seen. So that's one thing that's really important, that the office is ready for that. Of course, they need to have the experts and to deal with this new thing. When it comes to from the law firm perspective, I think, well, I remember the 1st of April 1996 when we had the community trademark and the protocol on the same day. See, that was a change. You guys only have Madrid to think about. But if I look back on what happened in the landscape of IP law firms, I mean, it did mean a change. I mean, let's be honest. It did mean a change. I think also because of the community trademark, that had quite a strong effect on the landscape. And I think you are not having it here, so for you, it's going to be less of a feel. There's going to be a slump, but then you will have, I was almost going to say hopefully, but that sounds wrong. Then you're going to have all the objections coming in. And I would hope for you, because you are needed, we need you, we need the experts, that this will even out the time that you get. The work will change. There will be less, I'm going to be really transparent now, there's going to be less low salary work, the assistant work will lower. So the filling in of forms, the filing, the higher salary work, you guys, you will be more busy because you have to deal with the objections and all of that. So the work is going to change. It's going to be more intellectually stimulating work. So objections, dealing with disputes and all of that. The fun fact now, you mentioned Mexico, it's about 10%. So Mexico is the 10th most designated country. And I thought, wow, that's big. And then I heard that actually it was only 10% of the number of total filings. I thought that was quite fascinating. So you'll be fine.
And I believe that Mexico was really an attractive country because most, like when you do that checklist, as you say, you are ticking which countries, it's easier. At least you say, okay, maybe a company in the past had doubts about protecting or not in Mexico. Now that we are part of Madrid, it's just ticking the box and paying the corresponding government fees. So if the mark matures into registration, then you are happy with that. If it maybe gets a refusal or something, well, at the beginning you were not really interested. So I believe that for most of Latin American countries that nowadays are not receiving the work, it's going to be easier for multinational companies to say, okay, let's tick now Brazil, which was not on our, because Brazil is the most recent country to join. No? So let's tick Brazil and let's choose it. Because maybe they, if it was a regular filing, they would not have done it.
They wouldn't consider.
But now that it's on the list, okay, let's include it. 61 countries instead of 60. Let's
Yeah.
put Brazil. So I think that's also an attractive thing.
Sure. And how important is the preparation of a trademark office?
No, I have to take this off. Preparation by the trademark office is critical. You know, there are many issues that the trademark office has to consider and decisions that have to be made before they become, you know, Madrid operational. The trademark office, as the office of origin, will take up new roles and responsibilities that they didn't have before, such as certifying the new international applications, transmitting information to WIPO, forwarding fees, among other things. and these tasks have to be performed or the owner's rights might be affected. And there are decisions that have to be made about how they're going to do this, how they're going to work. You know, they need to decide what's going to be the language, who's going to certify the international applications, are they going to hire new staff or train existing staff, who's going to learn the Madrid process, are they going to have specialists at the office who focus just on Madrid, or will they be using current examiners? How will the office communicate with WIPO? So there are a lot of issues to study and a lot of decisions that need to be made and need to take place before they join. So preparation to make sure a lot of your kind of office bureaucracy is ready is very important.
Okay, Luz?
Como ya dije, contar con equipos en las oficinas de marcas que conozcan a fondo el sistema es importantísimo, porque esos equipos en la oficina de marcas se convierten en el puente de comunicación entre el solicitante y la WIPO. Entonces, esa comunicación tiene que ser fluida y eso va a depender mucho de qué tan preparados van a estar los examinadores de la oficina de marcas. Importantísimo también, diría yo, en la preparación es poder tener muy clara el mapa de ruta, especialmente en Colombia, el tema de los términos, de cómo contar los términos, se vuelve muy importante a la hora de tener una oficina de marcas bien preparada.
Thank you. And how get your schedule of fees ready for the protocol? Eric?
Well, basically, as
This
we
is a
have been
good question.
discussing, yeah, it is. But all, like, if for the incoming work, so for the work that is coming from companies abroad that go to the Mexican trademark office, I believe you need to try to treat everything the same, like the regular filings and the provisional refusals for regular filings and provisional refusals for international registrations. I remember that in the beginning we were like, okay, so my client is not giving me the filings, this German company. So when we receive a provisional refusal, let's charge more so we can compensate or make up for the. But really, I believe the advice is don't be resentful. The thing is, well, they're using this option. It's another option on the menu, and they're using this tool to protect their brands. And if they receive a provisional refusal, it's the same provisional refusal that they would have received as if they had filed it regularly. So your schedule of fees has to be the same. Honestly speaking, that would be my advice. You don't have to treat it differently, even if it takes a little bit more time to get used to the beginning, because at least in Mexico, they were drafted differently. The ones for regular, it was a one-page document, and the ones for WIPO, it was 4 or 5 pages long because they included much more information, but you have to treat it the same. Now, for the Mexican companies that use the Madrid protocol, that have used, for example, my services to file in other countries, your schedule of fees, it really depends on a case-by-case basis. I believe that it really depends on the number of countries you are selecting. It depends on the classes. No, even though Mexico is not a multi-class country, let's say that they want to file in 6 different classes. Well, it would be different than in only one class. And if they choose, like, I don't know, maybe 5 or 6 countries or jurisdictions, it really depends on how you adjust your tariff. But the thing is just to be competitive, as we do normally, no? And not try to take advantage of this situation for the work that has been reduced with the filings that you received. No? That would be my opinion.
Luz?
En la experiencia colombiana, el tema de los honorarios va a depender igualmente del número de países y el número de clases que se van a seleccionar, y desde el punto de vista de los provisional refusals, que es lo que más recibimos en este momento, la experiencia ha sido algo variada porque cada provisional refusal trae ciertas complejidades, unos son más sencillos que otros, pero digamos que se mantiene en un rango de precios competitivos y caso por caso
Okay.
se revisa.
Thank you. And Tove, which kind of companies most likely use the Madrid Protocol?
Yes. Can I just add on
Sure,
to the
sure,
one
sure,
before?
sure.
I mean, again, with my in-house past, I know this was in the good old days, but I think many clients will feel the same. I mean, if you have an issue and you can't get your registration through, or you have an opposition that you have to deal with, and you want to sell the product and you have a problem with the trademark, I mean, getting help is really important, and why wouldn't you want to pay for it, right? So, from the brand owner perspective, paying for intelligent, qualified, high class advice rather than for filling in a forms is much nicer. So, yeah. So, I mean, your time is valuable. You're the expert. You should be paid. That's my opinion. I'm a girl from the good old days, but still, that I think so. I really think so. So, what kind of companies? I mean, I hear often that Madrid is just for the big multinational companies. This is not accurate because we have now about 1.5 million international registrations, which is quite a significant number. Out of these 1.5 million, 63 owners have one international, only one. They only have one international registration. Of course, that doesn't say 63%. That doesn't say anything about how many national registrations they may have, but it probably says something about the size. If they only have one international registration, it's because they are fairly small. They're not multinationals, right? 17% have two, 66% have three. Only the ones that have more than 100, so Novartis, for instance, who's the top of all, so those who have more than 100, it's only 0.11%. So actually, the system is used by a lot of small and medium-sized companies. As soon as you get more countries in your region to join, it's going to be really beneficial for your local industry, because they can then use the system to register in your neighboring countries in their immediate export markets. So the system is really for all sizes. I mean, not just for the big ones.
Eric and Luz, I think would be nice having your comments on that.
Well,
too.
I agree with what Tove is saying, but honestly speaking, the problem is in Mexico, if you see the statistics, we have received more than 100,000 applications from abroad designating Mexico, and it's just a couple thousand that have gone from Mexican companies abroad. And you're
Yeah.
going to say, like, well, why is this discrepancy? And when we first joined Madrid, this was the sales pitch by the government. This is going to
I see
help.
something familiar.
Really, it
in
was. This
Brazil.
is going
Yeah.
to serve the medium and small companies. They are finally going to have an option to protect their brands worldwide, whereas in the past it was impossible because you have to pay for the legal fees and you have to pay for government fees, and all these economic resources would be spent in developing other kind of things instead of wasting it on attorneys' money. Okay, but we see that it's the other way around. It's really not used a lot by Mexican companies, and I see two reasons mainly. Is first, the big Mexican companies already had protected their brands in the countries in which they have their corresponding presence and where they are selling the products or rendering their services. So it was not used for that.
Mm-hmm.
And second, the small and medium Mexican companies, usually when they expand, they want to go to either the United States or Central and South America. And if we see that nowadays it's only two countries in South America that are part of Madrid, which is Brazil and Colombia, well, we have Cuba, but
Cuba,
honestly
yeah,
speaking, Mexican companies, I don't see a lot going to Cuba.
Mhm.
But no country in Central America, only these two countries. Well, it's not an option for them. So that's why I believe the numbers are really small. if eventually more countries join from Latin America, I believe that the Mexican companies will have now a good opportunity to protect their brands and the numbers will be higher. But at least for now, that's why they remain so low.
Okay, Luz.
La situación en Colombia es inclusive bastante diferente que México, que es país hermano. En Colombia, desde el año 2012 a hoy han entrado 27,000 solicitudes de registro de marca internacional y únicamente 185 han salido de Colombia hacia afuera. Como ven, es un número bastante inquietante. Y yo creo que eso se debe también al tamaño de la economía, que pues es bastante diferente. Y estoy de acuerdo en que al momento que más países de la región se unan al sistema, muy probablemente los números de las solicitudes colombianas hacia afuera se van a incrementar y van a subir.
Yeah, I just, it may sound like there's a conflict between what we just said, but my data is from the sort of top overview thing. When you then look at it from the bottom up, it looks different. And I'm from Denmark, and of course, when you export from Denmark, you will export first to Sweden, Norway, UK, Germany, right?
Yes.
So in that way, the protocol is much more interesting for a company in that location. So again, once more the club expands with more members, hopefully, the system will become more and more relevant for your companies. So, yeah.
Yes. No, actually, I
Algo-
think that we must take in consideration the reality of each country, like Denmark, Mexico, and Colombia, and US, and Brazil. I mean, as I said in the beginning of the presentation, I could see Brazil much more like Mexico and Colombia. So you are in Europe, so we must take that in consideration too.
Yeah,
Right.
but the problem is more that your neighboring countries haven't joined yet.
Could be.
Yeah.
Yes.
I think so.
Yes, and I also think that, like talking about Brazilian economy, since we mainly export commodities, it's something that we must
Yeah.
take in consideration as well. So we are not exporting products that have already trademarks on that, So
Hopefully you will.
yes,
Hopefully
of
you
course.
will. I mean,
I'm
hopefully-
just talking about the
hopefully you will
current
all
situation.
Grow and I mean, a brand makes more money, so
Sure,
get going.
sure.
Yo para terminar quisiera decir que aquellas compañías colombianas que son grandes, que exportan inclusive por fuera de la región hoy en día, son compañías que ya tienen protegidos sus portafolios de marcas y por el momento de alguna manera no han sido, digamos, como tan entusiastas en utilizar el sistema.
Okay, thank you.
Yet.
So once you're a member, tips on how to decide if filing an international application is the best option. Would you like to comment on that, Eric?
Well, I believe that as we have been discussing, and it has been said all over this morning, this is another option. Really, you need to go on a case-by-case basis. This is not the best thing, but it is not the worst, or it's not, as I said last week in Brazil, it's not heaven and it's not hell. Really, it's just one more option on your menu, and you have to decide when the client comes to you how to use it. If a Mexican company comes and they want to protect in the United States, I would recommend not to use it in the United States, maybe because of sometimes Mexican companies don't have use, but they want to get protection. So basing their application on the Mexican registration sounds like a good strategy because you gain more years to begin using it and you get the registration and then you have to demonstrate use. It's between the 5th and 6th year. So that's an option. Sometimes Mexican companies include a really broad identification of products or services because even if they're not using, they want to protect everything. So that's why I would recommend to go regular or not with an international registration. If they have strict or a really restricted list of products and they already have use, then the international registration is a good strategy to go to the United States. So I believe that it really depends on how you use it and how you advise the clients. You need to really think of what their future is and what their intentions are, and depending on that, it's how you're going to choose what to use, which countries to select, etc. And as Tov was saying, if it's only a few countries, maybe you need to go regular, because then it's not worth it, no? But if it's really at, I don't know, 5 or 7 or 10 more countries, then for sure this is a good option.
Okay. Luz, Tove?
Yo diría que obviamente va a depender del caso por caso y de cada marca, y va a depender de la decisión del cliente, pero eso nos invita a estar más cerca del cliente, porque esto se constituye en una herramienta muy importante. Tenemos que saber en el momento justo cuando el cliente toma una decisión de exportar a un nuevo país, de si la marca es suficientemente distintiva o no, y estar muy cerca al cliente al momento de sugerirle una estrategia para utilizar un sistema como este. Entonces esa sería mi sugerencia.
Yeah. Of course, it's a matter of, I didn't go regular. I thought that was a very nice expression. I say go national, but go regular. It depends on the number of countries, obviously. If you don't, if you only need 3 countries, it's probably not worthwhile. It's too expensive. You need to have the basic mark, blah, blah, blah. However, if you think maybe in 5 years we're going to need 3 more countries, it could be worthwhile to do it now so you can do subsequent. If you know, you need to know what the trademark is, what's going to happen to it. If you're in the clothing industry and you want to protect a trademark, but you know it's going to go away in 5 years, then probably not use Madrid, because, you need to think about it. But because, as I said, the real beauty of the system is only once you get past examination, you get to renewal and all of that. So maybe it's in those cases, if it's a short-lived trademark, you want to go regular. So I think it's like you've said, it's sometimes it's down to a calculation of cost, but it's also about the quality, what is the trademark, what is going to be used for.
Okay. Thank you, Tove. And Tove, could you give us some advice on how should trademark searches be conducted?
Yeah. So the basic mark, you heard about this, the dependency period, the 5 years is really relevant. So you want to make sure to do very good searching on the country, your home country, the country that you're going to use as your basic mark. Because otherwise there is a risk that if it falls in the 5 years, that you will lose it. Okay, let's not forget you can actually use an old registration as your basic mark, so the chances are, the risk is not there. But so search the basic mark. It's just like before. You need to do proper searching in the country where you will produce. It could be, in our case, not in Denmark, but in Sweden. So you need to ensure production is stable. You want to search your launch market so nothing happens and you look stupid when you launch. So I think there's no really any change there. Then you may say, okay, tick a few more boxes and then you see if you get lucky. That's fine, but you want to do your searching just like before.
Okay, thank you. And how important are watching services with the Madrid Protocol?
Searches son importantes antes y después, es decir, sin el Protocolo de Madrid, las búsquedas siempre han sido importantes para poder detectar obstáculos, y por supuesto con la utilización del sistema de Madrid, las búsquedas siguen siendo un mecanismo importante para determinar la posibilidad de un registro o no.
Okay, thank you. And how to remain in
That's it.
contact
We're
with
done. It's
clients
perfect.
once same is using the Madrid Protocol?
So,
Tove, would you like to go first on that?
Yes, of course. That's I I will completely understand if you're worried about this. But I think clients have all kinds of work. I mean, they have, when they're selling in your country, they're going to have agreement work, they're going to have disputes, they need you, they should hire you to watch for published marks, so whether they should file oppositions. If they get unlucky, they will have counterfeiting and stuff like that. So hopefully the relationship will keep going. I mean, stay in touch with the client. Keep sending them your client alerts. Use other ways to stay top of mind. I mean, the client won't forget you. We never did, because we still needed you on a regular basis, because as you know now, getting through Madrid is not easy. So I think also, was that Brazil? If you don't appoint somebody, there's a risk of invalidation. Or was that Mexico?
No, Brazil, there is
Brazil?
a risk, but I mean,
So there are tricks on certain countries. In Canada,
No,
for instance,
just to
the
clarify,
IPO will not write to a
Tove,
foreign.
just to clarify, Brazil, there is a risk of invalidation just once the trademark is registered, and in case of you get
Yeah. So
judicial
there's going to be
citation,
local rules. But, you know, keep communicating with the client when something interesting and relevant for them comes up.
Okay, but what about the lack of information? If your client is using Madrid Protocol, and imagine that it's a successful registration, so we just go from filing to registration, and you are not aware of that registration that one client of yours has. How do you think
Well,
we can manage that? That's why when we had the question about the watching services,
Yeah.
because I do think it's important for a law firm to be aware of the protection that your client has in your country.
I'm going to
and-
be horrible now.
You go ahead.
Please don't kill me. But, I mean, the client will make the decision whether they want to tell you about their designation, successful designation in your country or not. I mean, for me, we used CompuMark as a watching, and in that case, you are also out of the game until something happens. I mean, honestly, I never lost touch with my people. There's always something. I mean, write to them and keep showing them that you know your staff, you're good at what you do. They won't forget you, I'm sure.
Luz?
Yo diría que sí son tiempos difíciles y sobre todo para tener como la información completa sobre los registros de un cliente. Y lo que yo he visto recientemente es que una de las formas de hacer eso es ir a la tecnología. Ofrecerle, por ejemplo, a un cliente un software as a service con una base de datos completa, digamos, e invitarlo a que se asocie a esa base de datos para él tener su información completa, darle un servicio 24 horas, 7 días a la semana, de forma eficiente. Yo creo que es una de las formas de mantener ese cliente cerca y, digamos, interesado en siempre estar en directo contacto con uno para efectos de tener esa información.
Thank you.
And you know, we can also rely on the typical really writing your clients. And it's something that we do is we know that they use the Madrid protocol. Maybe
Okay.
they get registrations that we are not aware of that.
Uh-huh.
So we write to them and say, okay, we know that you choose
To go
Madrid.
through Madrid.
It's perfect. Once you get your registration, inform us. We sell the watching service ourselves. So we sell it as a firm, and we said, okay, we can also watch for your trademarks for opposition purposes, but any marks that we are not aware of, it's impossible for us to watch them. So inform us. We would not charge because we only input the information on our database, and we include it on our periodical watching service. At least we know about those registrations,
Yeah, this is very important.
which is great, and you keep the trust of your client with you. So you sell that service. Well, by I mean selling it is just offering it, because
Offering.
really you are not charging for that. You would charge eventually if there's an opposition or something comes up, but really just for watching it, It's just part of the system that you have. And most Mexican firms do not charge for a watching service. No,
Okay.
it's part of the things that you have because they already entrusted you with their trademark portfolio. So you just include those marks that were registered. So it's something you can add.
It's an added value.
It's an added value, exactly.
If I can add to that, I mean, I don't want to make you pessimistic. I mean, one of my best agents or law firms, I was in the dairy business, so my company's products were on the shelves, and one of my best attorneys came back and sent me an email and said, "Oh, I saw that somebody's copying your products." Why would I not want to keep him updated so that he could look out for me on the other side of the planet? So, I
Sure.
mean, tell them exactly like you say, make sure not to sound bitter. Just offer the service and say, we are happy to put it in. We're going to, so we can look out for your best interest. You know, be offering your value. And I'm sure people will appreciate that.
Sure, thank you. Thank you, Tove. And Anne, which new services may arise to local firms in view of international applications?
Well, the U.S. experience is that the nature of the work may change. As Tove explained earlier, the work may go from, the kind of paper filing at the beginning to more work at a later stage. But in the U.S., the business of trademark attorneys did not decrease. It actually increased because it did cause more entities to file in the U.S. And then every time there's a action, even if they're filing through Madrid, the local attorneys must get involved. And the work on outgoing applications through the protocol will also increase because the trademark owners are going to need to come to you to figure out, as we said before, it's a tool in your toolbox. Is it a tool they should use? Should they use the Madrid protocol to file internationally? Where should they file? They're going to come to you for that advice there. And then if on an incoming application refusals are made or issues arise, the foreign filer is going to seek out local counsel for help. And finally, the trademark office is going to also experience an increase in filings, and therefore there will probably be additional work for the local law firms to deal with that.
Thank you. And so, any of you have something to add on that?
Nope, I'm good.
So we don't have a lot of time here, but we still have time for one or two questions. Luis?
Thank you, everybody. It was very helpful, your conversation. And Eric, again, congratulations. Eric was a few weeks ago in Brazil talking about that, and I already know his opinion. But I want to make one comment and one question. The comment is regarding the comment made by Tove regarding the duplication of fees that needs to be paid in some
The
countries.
second part.
Yes, like Brazil, you need to pay for an application and the registration fees. But filing through Madrid, in Brazil, we need to pay a third fee because we pay the local fees for the Brazilian PTO in Brazilian currency, and in addition to that, we need to pay in Swiss francs the fees for WIPO, which in Brazil is another issue because we need to send money out of the country, and this is not, there is a bureaucracy involved. And taxes also involved. So there is another complication to use the Madrid system. We don't pay in Brazilian reais for WIPO. We need to pay the Brazilian PTO, and we need to pay to WIPO fees in two different payments.
So the rise, is that for the basic mark or to pay the office the fee? The Danish office has a fee for handling the international application. That's true. Yeah.
So, but this was the comment. And the question is, in Brazil, as you all mentioned, we need to have a local attorney to receive judicial summons in case a lawsuit is filed in relation to that particular trademark registration. In other countries that, probably in Mexico and Colombia, that there is that this requirement does not exist, how do you serve the registration, the registrant, to respond to a lawsuit?
Bueno, muy buena pregunta. Para utilizar el proceso no se requiere un abogado y básicamente nosotros como abogados en Colombia solo nos vamos a enterar si el cliente afuera o la marca que está entrando a Colombia que tiene un proceso, una notificación de una denegación provisional o de un proceso legal de cualquier naturaleza, solo nos vamos a enterar si nos contactan del exterior. No tenemos otra forma, o sea, no hay una forma de hacerlo. Y esa es, digamos, una complejidad porque ahí estamos prácticamente a ciegas.
Eric?
For example, if I understand correctly, it's like if someone is challenging a mark, how would you notify the owner? No, in case, Mexico is more or less the same as Brazil because you don't have the obligation to record an attorney. So at the moment they designate Mexico, the application is handled before the Mexican trademark office, and eventually, for example, for a granted registration, if someone attempts to challenge that registration, at this moment, the thing is that you would need to go through a rogatory letter to do the corresponding notification, which creates a great problem, and it's really complicated because you don't have now that the trademark office in Mexico does not have the authority to notify WIPO, and then WIPO would be notifying the rightful owner. Mm-hmm. So you need to do all this process. We are in the midst of having a new law in Mexico, and hopefully it's going to be, I'm saying hopefully because they say that it's going to be including some provisions concerning this part. But we have not yet been able to see it. But eventually, if there's something that is included there, it's going to serve a lot so that we don't have to go through this lengthy process and really expensive process.
Something else to add, Luis? Any other questions?
If I may add, I mean, I'm going to be the cynic here, which probably won't come as a surprise by now. But the system has existed for more than 100 years. This problem, and I recognize the fact that it should not be complicated, it should not be bureaucratic and expensive and lengthy, but it hasn't really proved to be a big problem over the more than 100 years of the system. I mean, it's normally not difficult to find the owner of the right in question through WIPO or directly. But obviously, I'm not into the rules of how to serve in all of the 122 countries that the protocol covers. I can only say it's not really a big issue. But yeah.
Well, about Brazil, we cannot say much. We're just starting, but it's a problem. Like something that we are worried about. And
yeah.
So any other?
Should we just clarify about the fees? How to pay the fees? I mean, at WIPO you can create an account. Mm-hmm. I think we had an account, so they would pull the fees off the account, the Swiss francs. That wasn't a problem for the company. Of course, I had to first explain why do we have to have money sitting in Geneva, but once that was done, it was quite easy. I think now you can pay by credit card, or whether that works for you.
Or bank transfer.
Bank transfer. So it's a problem you're going to figure out.
Yes.
You'll find a way, I'm sure.
I don't know if I want to go deeply on that because, as I said before, like countries are different, and of course, there are some issues that we are facing in Brazil
Yeah.
once you're using credit cards or doing some wire transfer that perhaps doesn't happen in other countries in Europe. But
I just didn't want to
That's
leave it hanging
okay.
in the air.
sure, no, thank you, really. So, any other questions? No?
Really?
Are we good on time here?
Yeah.
Okay, so I just would like to thank you all for being here, for our great speakers. As we knew since the beginning, it would be this way. And just to finish it, I love the idea of having Madrid Protocol as just another tool on the toolbox. You know, Madrid Protocol is there and it's coming. And of course, Latin America wants to be part of the huge economy, worldwide. And we have to be open for that. Okay, so it's something else that we can offer to our clients, and again, decide on case by case what's the best option. If not, but it's another tool that we have there.
Open and prepared.
Yes, and just to finish that, something told me something recently that I think fits here quite well, is that when you are in an inevitable situation, don't lose your energy trying to push that away, but just welcome it, you know, because it's there. Madrid Protocol is there, and as a Brazilian, let's welcome it. Okay, thank you everyone for being here, and you're ready to go for lunch. Thanks.